This is an issue that every gun owner should be concerned about, and we in Congress should be concerned about it too.
The Supreme Court today handed down a major victory for gun control advocates,
declaring various federal gun restrictions unconstitutional in the state.
I want to see Congress pass laws that will help reduce crime without infringing on the rights of law-abiding citizens.
21 years and older who are allowed to own a handgun will no longer need a license to carry it.
This is big.
The Supreme Court just unleashed a constitutional earthquake that's about to shatter gun control laws across America. In a stunning emergency ruling, the justices declared that millions of Americans no longer need government permission slips to exercise their Second Amendment rights. This isn't just another court decision. It's the death blow to over a century of permit systems that controlled who could carry firearms in public. Right now, 43 million Americans hold concealed carry permits that might have just become worthless pieces of plastic. States that collected billions in fees, required months of waiting, and demanded extensive training courses are watching their entire regulatory framework crumble overnight. The constitutional revolution you're witnessing today will reshape how every American exercises their right to bear arms. The emergency docket operates like a constitutional fire alarm. When the Supreme Court acts through emergency powers, they're not suggesting change, they're demanding it immediately. Out of thousands of cases that reach the court each year, only the most urgent constitutional violations trigger this extraordinary mechanism. Lower courts don't get transition periods or implementation timelines. They comply now or face contempt. This emergency ruling carries the same force as decisions that stopped executions, overturned election laws, and blocked federal mandates. The justices reserve this nuclear option for situations where constitutional rights face ongoing violation, and they just used it to demolish permit requirements nationwide.
It triggers something in me that something has to be done.
Now, this is the most significant Second Amendment ruling in more than a decade.
The first major federal gun safety legislation in decades is now moving forward.
For the Supreme Court, it's all about language, reasonable suspicion, objective reasonable belief, or probable cause. The bill allows gun owners 21 years and older to carry a weapon in Tennessee without a permit.
State can't make everywhere a sensitive place. You can't go hiking in some places and not be able to defend yourself against somebody that you run into.
What makes emergency rulings particularly powerful is their ripple effect. The court doesn't simply address the immediate issue. They telegraph their broader constitutional vision. When justices invoke emergency powers, they're laying groundwork for permanent transformation. The permit systems that states operated for decades aren't getting reformed or adjusted. They're getting eliminated. Think about what this means for the 43 million Americans who currently hold permits. These law-abiding citizens followed every rule their states imposed. They submitted fingerprints, passed background checks, completed training courses, and paid hundreds or even thousands of dollars in fees. Some waited months or years for approval. Others provided character references, submitted to interviews, and justified their need to carry. A Texas resident who recently paid their $40 permit fee just watched that requirement vanish. California residents who navigated one of the most restrictive systems in the nation, spending upwards of $800 and waiting 8 months, did all that for nothing. New York City permit holders who endured police interviews, submitted notarized documents, and proved proper cause for carrying just saw their entire ordeal declared unconstitutional. The financial implications stagger the mind. Americans have collectively paid over $1.2 billion in permit fees during the past decade alone. That figure doesn't include training costs, fingerprinting charges, or the economic impact of time lost waiting for approvals. Some states charged reasonable fees, others turned permits into revenue generators, extracting $500 or more from citizens exercising constitutional rights. An entire industry built around permit requirements now faces existential crisis. Training facilities that offered mandatory courses, fingerprinting services that processed applications, administrative staff who managed permit systems, all of it rests on constitutionally questionable foundations. State budgets that relied on permit revenue must find new funding sources overnight. But here's where it gets explosive. Multiple states already face class action lawsuits demanding refunds for illegally collected fees. If permits were always unconstitutional, then every dollar collected violated citizens' rights. New York alone collected approximately $340 million in permit-related fees over the past 5 years. California's take exceeded that. The potential liability across all permit-requiring states reaches into the billions before calculating damages for constitutional violations. The training mandate collapse creates another seismic shift. 26 states currently require completion of safety courses before issuing permits. These mandates range from 4-hour basic classes to 16-hour comprehensive programs covering legal use of force, marksmanship, and state-specific laws. Approximately 3.2 million Americans complete mandatory training annually, spending between $75 and $500 per course. Constitutional rights don't typically require competency tests. You don't pass a First Amendment exam before speaking publicly. The government can't mandate voter education before you cast a ballot. Fourth Amendment protections don't depend on privacy training completion. If the Second Amendment receives equal treatment, every training mandate fails constitutional scrutiny.
It also puts state laws in jeopardy that are similar to this law.
But public safety concerns must be addressed in ways that are lawful.
The government may not regulate individuals' possessions of weapons for self-defense.
They really don't know what to do with this one, which is always a good thing to see.
There is a difference between states deciding how they want to regulate any number of things versus stripping people of their rights to self-defense.
The Second Amendment protects the right to carry a gun in public for self-defense.
The irony is that many gun owners actually support training. They just oppose government mandates. Surveys indicate roughly 67% of firearms owners believe education improves safety and responsibility. The gap between constitutional principle and practical preference creates tension within the gun rights community itself. Eliminating mandates might be legally correct while raising legitimate preparedness concerns. Even with permits eliminated, the battle over where Americans can carry continues. The Supreme Court acknowledges that certain sensitive places can restrict firearms, but defining sensitivity proves contentious. Historical examples included courthouses, legislative buildings, and polling locations. Specific government facilities with heightened security needs, modern interpretations expanded dramatically. Post offices, parks, public transportation, hospitals, stadiums, college campuses, bars, churches, and streets near schools all became gun-free zones. Some states responded to recent rulings by declaring vast swaths of territory sensitive. New York essentially banned carry throughout Manhattan. California created default prohibitions requiring property owners to explicitly allow firearms. The emergency ruling strikes at these expansive interpretations without eliminating the sensitive places doctrine entirely. Courts must now determine reasonable boundaries. Can states ban firearms from every government building or only truly sensitive locations? Do entire downtown districts qualify as sensitive? Can private businesses become gun-free zones by default? Legal scholars see the court moving toward historically narrow definitions. If trends continue, sensitive places might shrink to their original scope: courthouses, prisons, and active legislative chambers. Everything else opens to constitutional carry. That transformation would reshape not just permit requirements, but the entire geography of armed self-defense.
Not giving notice, well, that's required. Well, and when you take that away from people, you don't follow the rulemaking process, and you have to invalidate the rule.
Will allow scrutiny for all gun laws pertaining to everything: assault weapons, age restrictions, restrictions on magazines.
Saying setting a higher threshold in an emergency could mean life or death.
When things sound really good for gun owners in court, that doesn't mean it's over.
This will get appealed, and this might go back and forth a little bit, but for right now, this is where we're at.
The prohibited persons paradox presents another complexity. Federal law bars certain individuals from possessing firearms. Convicted felons, domestic violence offenders, drug users, those adjudicated mentally ill, illegal immigrants, dishonorably discharged veterans, and people under restraining orders. This list encompasses approximately 16 million Americans. Permit systems allowed states to screen for prohibited persons before authorizing public carry. Background checks during the application process caught disqualified individuals preemptively. Without permits, states lose this screening mechanism. They must rely on point-of-sale checks during firearm purchases and after-the-fact enforcement when prohibited persons get caught carrying. Critics call this reactive rather than preventive. Supporters counter that constitutional rights don't require preemptive verification. The government bears the burden of proving prohibition, not citizens proving eligibility. You don't demonstrate non-felon status before exercising free speech rights. A legal paradox emerges around enforcement. If someone prohibited carries a firearm, do they violate carry laws or possession laws? The distinction affects prosecution and sentencing. Some states treat illegal carry as a misdemeanor, while illegal possession brings felony charges. Without permit requirements, can states maintain separate carry offenses? The interstate reciprocity question looms large. Currently, permit holders enjoy carry rights in states with reciprocity agreements. If permits cease to exist, what happens to interstate recognition? Does constitutional carry automatically extend nationwide, or can states still restrict non-residents? The emergency ruling addresses permit requirements directly, but leaves secondary effects unresolved. States now face impossible choices. They can attempt to salvage their regulatory frameworks through litigation, knowing the Supreme Court has already signaled its position. They can accept the new reality and dismantle their permit systems voluntarily, or they can engage in resistance tactics that risk further judicial intervention. The smart money suggests most states will grudgingly comply while seeking alternative restrictions. Expect enhanced penalties for prohibited persons, expanded sensitive place designations where legally defensible, and increased enforcement of remaining gun laws. The permit era ends, but the broader conflict over firearms regulation continues evolving. This emergency ruling represents more than legal victory for gun rights advocates. It symbolizes a fundamental shift in how courts interpret constitutional freedoms. The same strict scrutiny applied here could extend to other rights currently burdened by government permission schemes. The precedent established today reaches far beyond firearms. Millions of Americans who never thought they'd carry guns in public now face that option. No permits, no waiting periods, no training mandates, no government approval required. The same constitutional freedom that protects speech and religion now fully extends to armed self-defense. The transformation will be messy, contentious, and revolutionary. States must rewrite their laws, law enforcement must adjust their procedures, and citizens must understand their expanded rights. The legal battles ahead will determine specific boundaries and limitations, but the core principle stands firm. Constitutional rights don't require government permission slips. The coming weeks will witness unprecedented change as this ruling takes effect. Court challenges will test its limits, states will probe for workarounds, gun rights groups will push for maximum freedom, while gun control advocates seek damage control. The only certainty is that America's relationship with firearms just fundamentally transformed. That's it for today, folks. See you in the next video.